Next case set for argument this morning is State of Ohio versus Victoria Sheppard and William Sheppard. It's case number 19CA0010-M and 19CA0011-M. Both parties are represented by counsel. I see that there are two appellants, so each side will have 15 minutes. You'll have to split that, figure out how you want to divide that 15 minutes. And you will also have up to 5 minutes for rebuttal. So just let me know how you decide to do that. The arguments are recorded and posted on the court's YouTube channel, so we ask that if you're arguing, you remain at the podium and keep your voice up so we have a good recording. The court has read the briefs in this matter, and we are prepared to proceed if you are. So, who will be going first? Yeah, one of the two of you. Will you be dividing your time between you?
Yes.
Okay.
Yes, Your Honor.
So a total of 15. Do you have any idea of how you want to divide that?
I may take 5 and I'll give her the rest.
Okay. All right. You may proceed then, sir. Thank you.
Your Honors, the court erred by enforcing a private policy of racial segregation violating the United States Constitution, and by failing to consider the criminal conviction was against the weight of the evidence, there was no evidence of a crime, and by failing to consider that we had no criminal intent. And on page 52, line 16 of the trial transcript, Judge McNulty himself said, "I do not think you were there for a criminal purpose. So why would you charge us as criminals?" We've never, well, this is very dangerous for black people. Police will consider me a criminal and possibly shoot first and ask questions later. This goes on all over this country. I am 65 years old and I do not need this. This puts my life in even more danger. Police shoot black people who are not criminals. Your Honor's proof of perjury is in Medina County Sheriff's Office incident report on 8/26/2018. Mr. Clark told police he was familiar with the person he located in his home. He further stated it was a prospective buyer of the home. And in the trial transcript, you can kind of start backpedaling.
Was this an open house situation, or was it advertised as?
We had gone to the open house, and then we just wanted to see the house again. We were excited about it.
So there was a for sale sign out front?
Yes, that's all they had was a for sale sign.
And the door was unlocked.
The door was unlocked the first time. I mean, the second time I think we went. And he said, well, maybe the realtor talked to him, and maybe they left it open for us. Because they did that at another house for us. So well, the trial transcript, page 19, line 12, Mr. Clark testified, "I told police you posed as prospective buyers." No, he didn't say that. He said we were prospective buyers. And Mr. Clark told police we took our shoes off. We spoke kindly with Mr. Clark and explained why we were inside to inspect the home. We never threatened Mr. Clark. And trial transcript, page 18, line 1, Mr. Clark testified saying he did not threaten me. No. I am being charged as a criminal for sitting in my car the second time in the driveway of a home for sale that I and my wife were interested in purchasing, and I think that is excessive. Trial transcript, page 14, line 24, Mr. Clark testified he tried to find the mold and could not find it. Mr. Clark was running dehumidifiers in the lower level during the open house, hiding the smell of mold. As a plumbing contractor, I am aware nature's stone creates leaks. And from his garage, it leaked across the front of the house, and then it went to the lower level, which we could have repaired that. But the day that the house was unlocked, we entered the vacant, unoccupied home for sale. We had never met the Clarks. We didn't know who they were. We had only been there with the two house openings. So we entered the unoccupied home for sale so we could be sure the home was safe for my wife, who has had 4 brain aneurysms, kidney failure, partial blindness, and a stroke. And I had to be sure the home was safe. I thought the home was for sale to anyone to buy it.
Let me ask you, the first
Yes.
time, I mean, I know you were there a couple times before you went with your wife without a realtor or anything.
Yes.
But he says that the car was parked in the back of the house. Is that where the driveway was? Is that where you usually park?
They have a part that goes around the front of the house, and then they have a part that's in the back. And I was just, we just parked in the back, we didn't disturb anything, we just gonna walk around the house. That's when we noticed the door was open, so we can walk in. Because she can't walk very far. Dr. Tai Chi told the police he was familiar with the Sheppards. They had left their complete contact information with 2 realtors. He didn't have to call the police. He had all of our information. He could have contacted us. I think it was just dirty pool all the way around. The police.
But he didn't call the police after that first time, is that, do I understand that correctly?
He did not. The very next day.
Okay.
Was that before you went out in the driveway then?
Yes. It's before we were in the front with Mrs. Clark. And had we known that they were present, we would have gone back. Or if we'd seen the sign, we're law-abiding citizens. We wouldn't have gone. I'd like to read something about the Fair Housing Act real quick. The court erred in proving that our presence was unlawful and not privileged by the fact that a for sale sign was posted in front of the home, doors unlocked, unoccupied, open for anyone wanting to view the home for sale. And the State versus Logston, 1660 Ohio Appellate 3D 517, 2005 in Ohio, it is necessary to prove that our presence was unlawful and not privileged. It is not enough to show merely that presence may have been unlawful. Examining a home for sale and inspecting a home for health safety is permitted by law as a legitimate business. I was a plumbing contractor. The black mold was causing ceiling damage and lower level damage from the garage. We were present conducting legitimate business, seeking and examining a home for sale. That's all I want to say.
Okay. You have a total of 9 minutes, 32 seconds left. Would you like to be heard, ma'am? Is it easier for you to stay seated?
No, I can do that.
Now, your total time is 9 minutes, 32 seconds left, so if you're going to save any time for rebuttal, let me know.
Pardon?
You will have an opportunity to, both of you will have an opportunity to argue after the other side does.
All right.
Unless you use the whole 932, I guess that's what I'm saying.
Okay.
All right, you may.
Thank you, Your Honor. Your Honors, the court erred by failing to acknowledge the Fair Housing Act, Section 842 U.S.C. 3601 and 3604, prohibiting housing discrimination because of one's race, color, or disability. The Fair Housing Act, again, the section that I mentioned, the statute authorizes certain persons to enter or remain upon immovable property of another when there is no notice forbidding this. The court erred by failing to acknowledge that we were conducting legitimate business, inspecting a home for sale for health and safety issues, as my husband mentioned. I am a scholar, and I spent many years in graduate school, and after which I had 4 brain aneurysms and a stroke. My eyes burst, and my kidneys began to fail. So it was very, very important to us that the house did not have mold. My husband, being a plumbing contractor, he did find that there was mold in the house. But inspecting a home for sale for health and safety issues is not against the law. Entering a vacant, unoccupied, uninhabited staged home for sale. We had no purposeful criminal intent, no mens rea, and as Judge McNulty said in the transcript, he said, I don't think you were there for criminal purposes. The Fair Housing Act authorizes certain persons to enter or remain upon immovable property of another when there is no notice forbidding this. We are included in the list of individuals who are authorized. Any person who has a legitimate reason for conducting business or communicating with the owner is not a criminal trespasser. Again, the Fair Housing Act prohibits discrimination in the right to access housing and in the sale of housing. Anyone of any race should have the right to access housing that is for sale. We were told never to come back to the neighborhood or even drive down that street. The court erred in
Can I stop you
proving,
for a second? When were you told not to come back or drive down that
when
street?
we met with the police at the Medina police office.
But was that after the first time you were in? And did you, after that
Yes.
morning, did you go to the driveway?
It was 21 days. They waited 21 days to notify us that we weren't welcome to come back. We didn't know, so we assumed it was okay to sit in the driveway and have,
Okay,
we
so
wanted
that's,
to pray about it.
that's what I was getting at. So the point is, according to your testimony, you had not been notified by the
Right.
police until after you had already gone to the
Right.
driveway and just sat in the
Yes,
driveway.
yes.
And according to what you're saying, the homeowner actually told you not to come back without a real estate agent.
Right, and so we thought that meant don't try to come in the house or anything like that. We didn't know that meant don't drive down the street, don't sit in the driveway and stare at the house, which is what we were doing. We were on our way to Cleveland to celebrate my birthday, and at the time, my vision wasn't very good. My eyes had just begun to burst, and I hadn't had the laser procedures done yet, and I wasn't seeing very well. That's why my husband pulled up behind the back of the house. Once he saw the door was open, he said, "Dr. Lee, do you want to sit down while I examine to see if the mold exists?" And I said, "Yes, I would very much like to sit down." But I wasn't singing because I could barely speak at that time. I wasn't singing, but I did have a birthday balloon. He was trying to cheer me up. Again, I was almost dead. The sheriff's report, in the sheriff's report, Mr. Kwok told the police that we were indeed prospective buyers, that he was familiar with us, and he committed perjury under oath when he testified at the trial on page 19, line 12. He said that he told the police we were posing as prospective buyers, but that's not what he said in the police report. So the court erred by failing to acknowledge that perjury was also again committed by Mr. and Mrs. Kwok. In the trial transcript, page 20, line 18, Mrs. Kwok testified, "We currently live at 5664 ABM Way, which is the house we were interested in." And Mr. Kwok, that's what Mr. Kwok said. And Mrs. Kwok testified later on that afternoon, or later on during the trial, on page 27, line 8. She said, "No, this is our home, and we still occupy the home. In fact, they live down the street in a brand new house." The police told Mr. Kwok that he should press criminal charges against us for entering an occupied structure. They lived down the street. We would never go into someone's house. We wouldn't break in, we wouldn't go in even if the door is unlocked. Again, we wanted to sit down and look at the house with William, who is he was a plumbing contractor for many years, and he's an expert, and he knew that nature stone was causing mold across the front of the house. It was a safety issue. The examination and purchase of a home is legitimate business. Prosecuting attorney Mr. Thomas Morris told the court on December the 19th, 2018, during the trial, "This is a gray area." So it was not clear why my husband and I were being charged as criminals after Judge McNulty himself on page 52 said, "I know you weren't there for criminal activity." I'm a scholar, and for the past 22 years I've been studying America. And what I understand is there's no such thing as the American dream. That racial segregation is upheld by individuals who are in power to make those types of decisions. Ohio is one of the most segregated states in the nation, and we were black people, even though I have a PhD, we were black people looking at a home in the neighborhood where the Shears and the Smuckers live. So we weren't welcome there, and that was made pretty clear. When we met Mrs. Kwok in the driveway, she told, at the trial, she said that I jumped at her as if threatening. I can barely walk, I can't jump. I can barely stand, I can't jump. I don't threaten people, I can barely walk. I was barely alive. I'm finished. Thank you very much, Your Honor.
All right, thank you. You'll have a total of 2 minutes and 18 seconds if you want to reply to the argument of counsel. right, good morning, council, you'll have 15 minutes.
Thank you. Pleases the court, my name is Tom Morris, I represent the state of Ohio. The facts in this case largely are not in dispute. On Ms. Sheppard's birthday, or prior to this, they were looking at the house. They had gone to multiple open houses, as you were supposed to do with your realtor, or at least during normal time.
Okay, so I want to stop right there.
Please.
Okay. So there's no dispute that they were prospective purchasers?
That was,
They had gone to, nobody's.
I don't know about their financing, I don't know if they could afford it, I don't know if
Well-
they wanted to, but yes, they were coming to look at the house. I don't think there's any, comes to the second point they made was that there was no criminal intent. If there was a threat, it would be a burglary. If they walked in with criminal intent, that would have been a burglary. If they had criminal intent to do something else while there, that's a different charge. She's charged with trespass, not being there, or being there when she didn't have permission to, or beyond the scope of what her permission, or their permission was. And that's what the facts that they admitted to in the beginning. They went there without a realtor, when it was not an open house. That was testified to by the owner of the property, and they wanted to see it again. Okay. You can't go into someone's house outside of the time for the open house.
I can't remember, did either of you say why the door was left unlocked?
Yeah.
The painters were coming or something?
The owner of the home had just moved down the street, and they were doing work on the house. They had a painter that was supposed to go in and do the paints. That's why he left the back door open. I don't know if legally it makes a distinction, it's trespass or not, whether or not you leave the door open or not, but that's why it was left open, according to the transcript. So that was the first time they came there, and there was a Mylar balloon that was hanging, and the Fox came in, or Dr. Fox came in, and said, "Why are you here? It's not an open house." And they made some small talk down and forth, and found out that not only she was there, but her husband was there as well. He was downstairs looking at the property, trying to examine it for mold. Fine, you're allowed to do that during open house, if you have an appointment to be there. You cannot just do this at any time you seem fit. That's trespassing. If you're there to steal, if you're there to assault somebody, that is a different charge. That's the charge of burglary. I mentioned the Fair Housing Act, and I believe, if I'm trying to put this in a legal understanding, somehow arguing that they have privilege to be there because of this civil action. Obviously, it's a civil action, it's not a criminal action. It was kind of a little mixed, and perhaps I didn't understand it, but I don't believe that there's any case law which suggests that the Fair Housing Act gives a person a right to go into someone else's home anytime they want to check it out. And that's what they did.
Well, I understand that there's kind of a hybrid here with them putting in the civil statutes and so forth. So really, the remedy would be just to sue.
And heck,
Okay.
so that's out there. But that's nothing to do with me, I don't believe, unless
No, I understand
there's
what
some
you're saying.
privilege that derives from there which would allow you to be in there. And that, I've never seen that. I have no idea. I don't believe that exists. To have unfettered ability to go into anybody's home that you have a perspective of purchasing if it's for sale.
Well, I understand you cite some case law, you cite some case law, but the sign does say for sale. So in essence, you are inviting people onto your property.
I don't know if you're inviting them to your property, you're notifying them that this is something for sale. Go ahead and look online to see the price. Call your realtor, call our realtor. The realtor's name's on the door. That's what you're doing. I mean, under their logic or their theory, they could go in at 2 in the morning and just check it out. You could do that. If it's an open house, or if open house doesn't matter, then anytime the house, if you have a for sale sign, anybody can walk in. What if people are living there? I don't think that's the right law.
Well, in this situation, though, everybody admits that nobody was living there, right?
Nobody's living there. Somebody was occupying that structure, it'd be found.
I understand that. What I'm saying is, in this particular situation, the state concedes that nobody was living there, and they had been there on prior occasions for open houses.
Yes, and yes.
Now, if they had just driven on in and not opened the door, but gone around and looked through the windows.
That was that case that we talked about out of the first district, and that court said no. The dissent said that's okay. There's, we can get into hypotheticals, I guess. When I'm looking at something like that, I would say is that if I'm walking in the front door, I have a right to be there. That's open to the public. If I go around back and start peering in windows, probably not. If you're in the curtilage, there's an expectation of privacy. But if you're in the front and you look in the window, I don't see a problem with that. I don't see a problem with that.
So in the front, but not going to the back and looking
I
at it.
think that's a problem.
And that becomes a trespass then.
It becomes trespass. If you are not permitted to be there, it's not your property, and there's no reason to believe that you've been invited to do that. That's beyond the scope. That was the first one. The first one I believe is clear. The second one, at that meeting, the first one, the owner of the property testifies, says, don't come back to the property unless you have a realtor. And they came back to the property. That's the second charge for trespassing.
Let me ask you, in your brief, you quoted the homeowner as testifying that he told them that they were not allowed to come back. Didn't say anything about without a realtor. So which one was it there?
I believe, he said it on multiple occasions, do not come back, and I believe I quoted him, or had him quote in the transcript, don't come back. He may have said the realtor or not, I don't recall the transcript.
I'm just telling you what's in your brief, and I know the other side is saying, don't come back without a realtor.
Either way, it didn't happen. It didn't come back with the realtor, and it came back. The brief says what it says, or the transcript says what it says.
Oh, of course,
So
we'll read that.
leave to the discretion of you. So the question then is, can they say, don't come back to the property? Does that also include not driving on the driveway? Sure. You cannot come back to the property.
Well, did he say you cannot come back to the property, or did he say you cannot come back?
Can't come back to the property. If I remember correctly. So, and he came back, and they came back, and whether they were praying on it or not, I don't know. But the wife was following them in, so they didn't certainly have time to go out and leave. She just happened to be behind them.
And she knew at that point, her husband had told her that this African-American couple had come and looked at that. So
I don't know if they said African-American or not. They said there was a couple that came. Can you believe this, or something, that someone was in the house when we got there, and I believe that type of conversation occurred between them.
why did she notice them?
Why
She
did
was following them.
Because there was no one there that was supposed to be at the house. It
No,
wasn't-
I didn't realize, I thought you said, I might have misunderstood you, I thought you said that she was following them, and then they pulled in the driveway, but she seemed to be
The
already
clocks, or
aware of who it was.
the people, or the owners of the house live in that development
I'm sure I
still.
understand that.
So they were following her by happenstance, and then someone pulled into their old house. She had, a week earlier, had that situation when the police were called, I believe, before that. And then she
The
followed
police were
them in.
called before that for what?
Police were called, a report was made after the initial incident, but before the
Oh.
second.
I thought you were talking about another instance where somebody went in the driveway, sorry about that.
No, that's my understanding. State's not standing up here saying these are bad people, that they don't have a right to live in the house, that they don't have a right to purchase the house. You just have to do it a certain way. You do it during open house. You do it with a realtor. You do it, make communications. You cannot just stop at someone's house and go in. It may not seem like a big deal, but that's where a small mistake can turn into a large mistake. A small mistake going into someone's house, what if somebody was there and not knowing or not taking the steps and an altercation occurs, or someone tries to defend their property in some way and then something happens. That's what we're concerned about, the trespass. No one was hurt in this, no one, just a mistake by them. You cannot go on their property.
Okay, so let me ask you this,
Sure.
did the police, you said the police report, I'm not sure, was it filed the next day or something?
I believe so.
Okay, after the first incident, but nobody had notified them from the police to stay away from the property at that time, before they went for the driveway?
Nobody notified them.
I mean the police, officially.
Police did not notify them, is that your question? I don't believe so. I believe that they had referred the matter out for charges. Those charges were not authorized yet. Those charges were not authorized until the second incident. And once the second incident, the charges were authorized for both cases.
the only notice they would have had was from the homeowner.
Were they charged on, I'm not hooked up, I'm trying to get the statute. Were they charged under the section of the statute that required notice?
So we're charging the A1 part of it. I think it's A1 part of it. Not the A2 part of it. A2, I think, is you can extend it and then you can ask them to leave and they don't leave. A1 is you were there when you weren't supposed to be.
Both charges were A1.
I believe so. 2 counts against each. The A1 charge. Any other questions? Okay.
All right, thank you. You have 2 minutes and 18 seconds if you would like to respond. Total time.
Yes, Your Honor. We were there with our realtor. They had a dehumidifier going, and that's what prompted me, they're hiding something. And this is why.
They had what?
We knew that there was something that was hiding because the dehumidifier was constantly
Oh.
running. So this is why I wanted to go, when I saw the door was open, I said, let's give me a chance to see what that smell was. Now, had they notified us that they were gonna press charges or anything, we would have gone back. We said, there's 1,000 houses for sale, why? You know, we didn't have any proclivity just for that house. My wife, she liked it, but there's 1,000 other houses. But there was a case very similar to our State versus Logsdon, 160 Ohio Appellate Court, 2005. And it's necessary to prove that the presence was unlawful and not privileged. And it's not enough to merely show the presence may have been lawful. But examining for sale, expecting the home for health reasons, is permitted as legitimate business. And I was very concerned about my wife's health. Thank you.
All right, thank you both for your arguments. The court will take the matter under advisement, issue its decision in due course. The clerk of courts will mail each of you a copy of the decision on the day it's released. You can also find the opinion on the Supreme Court of Ohio's website. Again, thank you both for your arguments.
Thank you.